Let's begin with the foundations. Welcome to another lecture. Today we examine the murder of Austin Metcalf, a high-profile case at the intersection of youth, criminal law, race, and the corrosive dynamics of social media. I am Professor Alexei, and with me is Priyanka, whose questions are, as it were, the conscience of our inquiry.
So, I guess we can start by thinking about what this case is exactly. It is a fatal stabbing between two 17-year-olds at a high school track meet in Frisco, Texas, and it quickly became a national story. We keep seeing law terms and online arguments, so maybe we should define the key terms first.
To frame our discussion, self-defense first. In Texas, as elsewhere, it is a legal justification for using force to repel an immediate threat. Its contours hinge on reasonableness and imminence, and the jury must be persuaded that the force used was justified under the circumstances. Next, a Batson challenge. That is, an objection to striking prospective jurors on the basis of race. If raised, the striking party must offer race-neutral reasons, and the judge decides whether those reasons suffice. Then, sudden passion. Under Texas law, if the jury finds the killing occurred under immediate, intense emotion from adequate cause, punishment for murder can be mitigated. If not found, the standard range applies. Finally, doxing. Publishing private, identifying information about someone online, typically to intimidate or endanger them.
I often think definitions keep us honest. But why does this case matter beyond Texas? It touches juvenile crime because both were 17, and in Texas, that means adult prosecution. It also touches race because, public debate often framed it that way. And it shows how fast misinformation travels when the facts are still forming.
Indeed. It's important to understand that in Texas, defendants aged 17 are prosecuted as adults, which substantially raises the stakes while still excluding the harshest penalties such as life without parole or the death penalty in such circumstances. Historically, misunderstandings proliferate around self-defense and provocation. The public often collapses complex reasonableness standards into binary moral judgments. In parallel, racial discourse frequently proceeds without evidentiary moorings. Officials may disclaim race as a factor, yet online narratives can crystallize around it regardless, particularly when jury composition and community tensions are already fragile.
Building on that, can we lay out the basic facts? Anthony and Metcalf did not know each other before the incident. The setting was a track meet at David Kuykendall Stadium in April 2025. Thunderstorms delayed events, and athletes crowded under tents. There were disagreements about whether it was acceptable to sit in a rival school's tent.
As we continue, witnesses recounted that when Carmelo Sincere Anthony from Centennial High School was in Memorial High School's tent, he was repeatedly asked to leave. One student estimated as many as 15 times, though accounts varied. During a brief escalating exchange, some witnesses said Anthony warned, "Touch me and see what happens," while reaching toward his backpack. Accounts differed on who initiated physical contact. Some described Austin Metcalf, an MVP linebacker from Memorial, as pushing or grabbing Anthony. Anthony produced a black knife from his backpack and stabbed Metcalf once in the chest. He fled the scene. Metcalf ran for help and was pronounced dead minutes after arriving at a hospital.
After the arrest the same day, Anthony said, "I was protecting myself." He also asked whether Metcalf would be okay and whether it could be considered self-defense. He was charged with murder as an adult. In April 2025, Judge Angela Tucker lowered the bond from $1 million to $250,000, citing his clean record and school leadership. He was released on conditions. The case drew national attention. His family raised funds on GiveSendGo, and Metcalf's family and his employer used GoFundMe.
Moving forward, a grand jury indicted Anthony for murder in June 2025. Jury selection began in June 2026 before Judge John Roach Jr. The defense raised a Batson challenge after the prosecution struck 3 black female jurors. The prosecution offered race-neutral reasons, namely that they were teachers of school-aged children, and the judge allowed the strikes. A jury with no black jurors was seated in June 2026. After evidence and argument, the jury found Anthony guilty in June 2026, rejecting sudden passion, and sentenced him to 35 years. He was then transferred to the Texas Department of Criminal Justice's Wallace PAC unit and filed notice of appeal. Before we get to the complexities, a brief personal note. As a mathematician by training, I am inordinately fond of definitions, not because they drain the world of nuance, but because they help us encode nuance with precision. Much as in chess, where a position that looks chaotic becomes legible once we map lines and threats. In legal matters like this, clear definitions are our only prophylaxis against confusion multiplying faster than the facts.
I've been wondering about this. 3 big questions might organize our thinking. First, did race play a role in the incident or in the trial outcome? Second, what if thunderstorms had not delayed the meet? Third, how does misinformation shape public understanding of legal cases like this?
Let's proceed to the first question. Did race play a role? Officially, the Collin County District Attorney stated, "This case has nothing to do with race." The victim's father likewise rejected racialization, even publicly disavowing a white nationalist protest that tried to claim his son's image and message. However, social media narratives rapidly framed the case racially. The absence of black jurors, coupled with a failed Batson challenge, catalyzed skepticism. Outside the courthouse, rhetoric escalated, including a far-right activist calling for Anthony to be lynched, a term whose history is unambiguous and abhorrent.
Can we say that jury composition was the key driver of public doubt? I am curious about how the Batson process actually works here, because some people heard race-neutral reasons, but still felt the outcome did not look fair.
To elaborate, in a Batson sequence, the defense objects that the prosecution used peremptory strikes based on race. The prosecution must then articulate race-neutral reasons. The court evaluates credibility and consistency, and if satisfied, the strikes stand. In this instance, the court accepted the explanation that the struck black female jurors were teachers of school-aged children, a rationale the judge deemed race-neutral. Legally sufficient does not always equal publicly persuasive. Optics matter in collective confidence. We observe a divergence. The court finds compliance with Batson, yet communities view the all but absent black representation as emblematic of systemic shortfalls. Both statements can be true in their respective domains.
So yeah, moving on. If we ask whether race played a role in the incident itself, we do not have evidence in the arrest report or from officials suggesting it did. But the public discourse, protests, and even fundraising platforms reflected polarized racial narratives. That is a social fact, even if not a trial fact.
This logically leads us to question 2, the counterfactual. What if thunderstorms had not delayed the meet? Heavy rain compressed athletes into limited tent space. Informal norms about sharing shelters were ambiguous. One coach testified it was unusual for rivals to share a tent. Another said such sharing was not unusual, especially in storms. When norms collide, enforcement becomes improvisational, and misunderstanding can escalate quickly. Without weather delays, the 2 students from different schools might never have occupied the same narrow space. The confrontation may have been avoided entirely.
What if we thought about it like this? Could school officials have reduced the risk once they saw tensions rising? For example, by clearly relocating athletes or enforcing tent boundaries earlier. Do we have indications about that kind of authority in the record?
Speaking of authority, it is worth noting that timely, neutral intervention often functions like a safety valve in crowded environments. If coaches or administrators had swiftly separated groups, clarified shelter policies, or redistributed space, physical contact might not have occurred. Additionally, the policy versus law gap matters. Carrying a knife can be lawful in Texas but violates school policy. The legality of possession did not decide the matter. It was the act of using it in a brief confrontation that did. More assertive enforcement of school rules earlier in the day, on space and conduct, could, theoretically, have prevented the chain of events from reaching that point. De-escalation is usually mundane in the moment. In retrospect, it is everything.
To shift gears a bit. Question 3. Misinformation. This case had a fake social media account impersonating the Frisco police chief. It pushed a fabricated autopsy report that went viral before being debunked, and authorities investigated the impersonation. There were also rumors that Anthony's family bought a car and a $900,000 home with donations. Snopes reported there was no evidence of that, and that funds had not been withdrawn when the claim spread.
On to our next point. Crowdfunding became a proxy battlefield. Anthony's family raised over $515,000 on GiveSendGo by May 2025. Metcalf's family and employers' GoFundMe pages raised nearly $250,000 combined. GiveSendGo's founder publicly compared the case to Kyle Rittenhouse and Daniel Penny, which transported this incident into a pre-existing culture war frame. Comments on Anthony's fundraiser became so toxic that the platform disabled them due to racist and derogatory content. Parallel to this, doxing and swatting targeted both families and even Judge Angela Tucker, who had earlier reduced Anthony's bond. The FBI and local authorities investigated threats and swatting incidents, including one where a tactical team arrived with weapons drawn. The online environment was not mere noise. It altered personal safety, employment, and community trust.
I'm curious about the longer horizon. If misinformation becomes embedded before trials, does it affect jury selection or sentencing, even indirectly? Or maybe it mainly affects legitimacy afterward, when people assess whether the verdict feels just.
In this context, we can infer several channels. First, pretrial contamination. Extensive viral claims can saturate a venire, requiring larger jury pools and more probing voir dire, increasing the risk that latent biases slip through. Second, ambient pressure on institutions. Judges and lawyers operate under heightened security and scrutiny, which can chill public communication. Third, post-verdict legitimacy. When misinformation races ahead of corrections, the social memory of a case may diverge sharply from the record. We need further research with longitudinal designs to evaluate how falsehoods affect case processing and public trust. The problem resembles epidemiology, where the reproduction number of a rumor often exceeds the capacity of corrections to catch up.
Maybe it's just me, but the human cost feels central. Both families endured doxing and swatting, both fathers lost their jobs, and outside the courthouse, emotions spilled over. After the verdict, there were confrontations. A far-right activist called for a lynching earlier in the week. Civic groups split publicly. Some praised the verdict as justice, others condemned it as over-prosecution and a failure of representation.
In conclusion, we have described the murder of Austin Metcalf, the April 2025 stabbing at a rain-delayed track meet, the adult murder charge against Carmelo Sincere Anthony, and the 2026 trial ending in a 35-year sentence with the sudden passion claim rejected. A notice of appeal was filed thereafter. We examined 3 questions: the officially denied yet publicly asserted role of race, the counterfactual of bad weather compressing norms and bodies, and the distorting influence of misinformation. For a related comparative study of self-defense narratives and public polarization, consider the Kyle Rittenhouse case, noting, of course, its distinct facts and jurisdiction. Thank you for listening. May we all keep our definitions precise and our judgments humane.
So, I guess that kind of sums it up. Thank you, Professor, and thanks to our listeners for joining another lecture. Take care, everyone. Until next time.